IP field and their leadership in the technological area. So more the IP filing connotes more technological leadership. A higher level of technological leadership if the patent filing is more. That's what I want to convey. Next slide, please.
Yes, sir.
Now, there is another data. Next slide.
Yes, sir. Just a minute. Yes, sir.
Next slide. Am I audible?
Yes, sir. Yes, yes.
Hello.
Yes, sir.
Am I audible?
Yes, sir. Audible, sir.
Am I audible?
Yes,
Next
sir.
slide.
Yes, sir.
Next slide.
Yes, sir.
So now the USA. No, USA. You see, we all know USA is the most technically advanced country. You see, it is because their IP culture is a stronger root. Their IP culture has a history of around 200 years. I give you a classic example. Read this US patent number 223898. This was granted to Edison. It is about the incandescent lamp, which is still being used or must be being used in India. Its patent was granted in 1880. Now, basically, let me tell you, even this Edison company was faced with an infringement suit from another company. That company alleged that Edison company is copying their patent. The patent number is not here. So 1880, and this case has gone to the Supreme Court. I'm talking about that 140 years back, there was a patent litigation about a incandescent lamp, which has gone to the Supreme Court, US Supreme Court. What I want to convey, the intensity of IP activity. Do you know that in USA, in a year, around more than 4,000 patent litigation cases are filed? In India, the total patent litigation cases, Dr. P.K. Sahu is there, you can count on your fingertips. So obviously we lack something. The total filing in India since the last 7 or 8 years is hovering around 50,000.
Okay.
And out of 50,000, 60% patent applications are filed by foreign nationals. 17,000 patent applications filed by Indian applicants. Out of 17,000, educational institutions filed around 2,000. And out of 2,000, mostly this is filed by IIT and ISC. What about second-tier institutions? So the situation is very bleak. And let me tell you, even all this filing, etc., is started after signing a peace agreement. It started up 2000 onward. So what is the history of our IP culture? 20 years. So we need to do a lot. This IP literacy mission has to pick up. It has to have requisite intensity. But let me tell you on the positive side that India is also among the top patent filer. So things are not that bleak. The only thing is that we need to do more. We need to do more. There is another patent application, US patent application, Gillette. Everybody uses this Gillette blade. Now the first patent was granted in 1904 to gentleman Gillette. And it's a 5-page patent document. And there are 30 claims. Even now, even the patent professionals in India can learn a lot by reading the claim drafting of this particular patent. Next slide, please. Next slide, please.
Yes, sir.
So basically, this is a drawing of Thomas Edison incandescent lamp patent. You see, this shows the electrical bulb vacuum within a glass. Next slide. There's some problem?
Yes, sir. No, sir.
Oh, okay. Next slide. Yes. So this is the patent document. So basically, I will urge every PhD student to download this patent application and read it thoroughly. You see, this patent war was fought in USA 140 years back about incandescent lamp. And there was an interesting story before filing this patent application. Thomas Edison will have set up an experimental lab in his house. In one room, he will call investors and show in great secrecy how the bulb will work. And everyone would be amazed that how can a light bulb can work for continuously 7-8 hours. And they, after seeing this functioning of the bulb, they started investing in this firm, and the rest is history. It is said it is one of the most important patent which has earned the highest amount of money for the Edison. It is a part of legend. Now, coming back to the intellectual property rights. So having having tried to convey the message that IP literacy, IP culture is necessary ingredient of excellence, and any society which is trying to progress on the technical advancement has to have IP culture as a necessary part of its curriculum, as a part of scientific or R&D or educational activity. So what is the intellectual property rights? Basically, it's a legal created monopoly rights over intellectual creation in industrial, scientific, literary, and artistic field. So basically, you take any gamut of human activity, if you contribute delta, there is a scope. It meets the criteria, requisite criteria, that you can enjoy monopoly rights. Next slide. Next slide. So basically, intellectual property rights is legally created monopoly rights over intellectual creation in industrial, scientific, literary, and artistic fields. Okay. So, and basically, legal system of intellectual property rights, third bullet, convert this creative outputs into tradable property. So, for example, if I've invented the laser pointer, suppose a laser pointer, existing laser pointer works for 100 hours. I did something, maybe I improved the laser cavity working inside this, so that it starts working for 1,000 hours. Then, and nobody has done so far throughout the world, I can take a patent right for the improved laser pointer. And by taking a patent, I can exploit it commercially for 20 years. What I am to convey that if I take a patent for the laser pointer, then I can realize the value. If I don't take a patent, if it is the knowledge in public domain, then anybody can use it. So basically, the primary function of intellectual property rights is that it makes the contribution of innovator a legally protected right, and as long as it is a legally protected right, only he can, with his permission only, with his license only, it can be used in India. If he has taken a patent in India, if he has taken in other countries, he can enjoy monopoly rights in other countries also. Next slide. So basically, previous slide. So basically, intellectual property rights are legal rights. There has to be a law, Patent Act, Copyright Act, Design Act, Trademark Act. These are territorial in nature, essentially. But if you take a copyright, if you publish a research paper, and then if you write a novel, by virtue of the Berne Convention, your rights are protected throughout the world. Even if you don't you don't approach the copyright office, you have a proof that you have written that novel without copying from others, you can enjoy rights throughout the world by virtue of the Berne Convention. Now, basically, it provides monopoly to the holders of rights for certain acts. I will not go in detail, but the fourth bullet is very important. It enables holders to stop third parties from unauthorized use. The essence of IP right is that holder of the right can stop third parties from exploiting without his permission. These are limited in time, and then it provides right to protect. It's not necessary that if you have taken a patent, you can enjoy, it will be commercially viable. World over, only 7 to 8% patents are really exploited. Next slide. Next slide. So basically, there are 7 kind of, previous slide. Yes. So basically, IP is a strategic tool. Brand promotion, technology export, but last 3 bullets are very important. Important for academic institution. Improving quality of R&D, facilitating collaboration with industry, and capturing, recording innovation. Why improving quality of R&D? I will discuss in great detail. Basically, every year, as I told you, patent applications are filed throughout the world. Now, China files 15 lakh patent application in a year. Similarly, once a patent application is filed, the entire information content, next slide, it's a blank slide. It's showing blank, yes. Okay. So basically, once there are 100 million patent documents available, freely available on the net, 500,000 is added every year. So point is, if a PhD scholar is not carrying out a patent search in his area, and still he claims that he is aware of a state of art, he is making a misleading statement. If you want to know the state of art in your area, then you must be able to carry out a patent search. That's what I want to convey. Entire knowledge in your area is available in patent document. State of the art is available. If you are not carrying patent search in your area, then you are not aware of the state of the art in your particular technological area. There are 7 types of intellectual rights: patent, copyright, design. I will patent, copyright, design, trademark, trade secret, plant variety rights, GI. Next slide. Next slide.
Yes.
I will quickly explain this thing, everything here. Now, the patent, basically, this rights is given for a process or a product. The lifetime is 20 years. There is a criteria. Your contribution delta has to be novel, non-obvious, and useful. There is another trademark. Trademark companies, everybody knows. This right can go perpetually. Every 10 years, you have to take a renewal of your right. You have to approach trademark office, and it protects the name, logo, etc. Third right is copyright. It is very relevant for researchers. It basically, it's about written words. It protects the literary work, musical work, etc., etc. Here, as far as, suppose, even if you are writing a letter to your spouse, as long as it is original, you can take a copyright protection. The beauty of the copyright is that, as long threshold is very low, as long as if you have written a 4-line poem, as long as it is not copying from others, there is some selection, you can enjoy copyright over 4 lines of poem also. It would be another matter that nobody would like to read your poem. Maybe you will also not like to read it after some time, but still, as long as you have created, you enjoy the copyright over that 4 lines of poem. It's a very comprehensive. In fact, there could be 3-day seminar on the copyright only, so I will not go in detail. But one thing I would like to caution you: here the right extent of right, the duration is very large. Life of the author for 60 years. So if you are visiting any internet sites, don't think if it is available in the public domain, it gives you right to download it and distribute to other people. So in some countries, even downloading could be a crime. Downloading could also be termed as infringement. So you should be very careful if you are taking any material from the internet. You should be very careful. Merely the fact that it is available on internet it doesn't mean that it is free from copyright also. The fourth right is design right. It protects the appearance of an item. People have taken protection for the appearance of the motorcycle, a laser pointer, and goggles, aeroplanes, helicopters also. Basically, it protects the appearance of an item. It doesn't protect the functioning of the item. It protects the appearance. GI is basically a community right. It is given to only association of person. It is about this Banarsi sari or Kanchipuram sari, Alfonso mango, etc. And then plant variety right is about the basically it is for the plant breeders right. I will not go in detail. Next slide, please. The last right is not very important. Now, what I want to convey that whatever you might be doing, you may be a scientist, you may be an author, you may be a story writer, you may be a plant breeder, you may be a semiconductor chip maker, you may be a designer, packaging expert, how to package a functional elements of an item so that it appeals to the eye, dial of a watch. You see, in any area, if you have contributed, there is a corresponding law. And if your contribution fulfills those criteria, you can enjoy a monopoly right. Design rights is for 15 years. Now, there is a bundling of right also. So look at the laser pointer. This is a laser pointer. If I have made contribution in the functional part, earlier it was functioning for 100 hours, now it is working for 1000 hours, I can take a patent. And my right will last for 20 years. I can take patent for the functioning of this laser pointer. Now there is another right, design rights. If I package in a manner so that appeals to the aesthetic senses, I can take a design right. These rights will go for 15 years. The beauty is single item protected through variety of IP rights. What is the beauty? The importance is that every type of IP right gives me additional protection, additional barriers for the copycat. Suppose my patent right expires after 20 years. What will happen? After 20 years, anybody can copy the functioning and details of my laser pointer. But if I have taken a design rights for the appearance, he may not be able to introduce the same laser point in the market with the same appearance for which I have taken a design protection. Even if he is able to copy that particular appearance, if I'm selling it with a particular trademark, he will not be able to sell the laser point in the market with the trademark for which I have taken the protection. What I am trying to convey that it's a strategic thing. IP, you see, I mean, the flexibility, the bandwidth of IP system provides you an avenue to extend the right. I give you a classic example of, everybody is familiar with Dolby. Ray Dolby was a sound engineer. His first patent was granted in 1969. It was basically earlier when you used to play tape, you see, there was a background hissing sound. He made an invention so that a hissing sound was removed. Now he was granted a patent. The story is around 1969 or 70. Now imagine he was granted a patent, but right will be there for 20 years only. After 20 years, anybody could have copied his patent. Now he has a bright idea. What he did, he didn't make the tape recorders himself. He licenses, and he asked every tape recorder manufacturer that, okay, I am giving you technology. What you are required to do, that you play an additional button on the tape. So if somebody wants to listen to the good music, he will have to press that button, and that button will be named as Dolby. Now what is the essence? What he achieved by doing this, that you see, all the tape recorders, they are having a separate button with the Dolby. Now, after 20 years, anybody could have copied his invention, but nobody can produce a tape recorder in the market with a Dolby button. Why? Because Dolby was his name. So what happened in the 20 years, people have started associating the quality of sound with the name Dolby. So he has extended his right to an indefinite period because trademark is indefinite. See the beauty of licensing strategy. What he has done, he has the value which was there in his patent, he has transferred this value to the trademark. You see, in the 20 years period, intervening 20 years period, in the intervening 20 years period, he has transferred the value associated with the patent right very cleverly in his name Dolby. And now, you see, I was surprised. I purchased a Samsung mobile, and now even this mobile has a separate button. You see, if you go to the setting, there is a separate setting button for that, and it says Dolby. If you want to listen to the Dolby sound through a headphone, you will have to press that button Dolby. And now Dolby is almost synonymous with the quality of the sound. That was achieved by the clever strategy. We call it clever IP strategy. You see, patent right is separate, but he extended it. That's why the companies, they employ IP strategies, because it's not only knowing what is patent, copyright, design, etc., etc. How to play out in the market, as the principal sir has pointed out, that from ideation to prototyping, testing, so pilot program, then ultimately in the market. In all these 4 or 5 steps, it is important to have a IP person associated with the development, because he will be telling you, I cannot go in detail because of the paucity of time. Every step will be guiding you. The moment there is an ideation, file a patent application. Moment there is a prototyping, file a design application. Moment you are going to introduce to the market, in addition to patent and design, file a trademark application. So basically, with all these instruments, you are trying to put barriers to the copycat. Even if they are able to copy your patent, they cannot copy the appearance. Even if they are able to copy appearance, they cannot sell in the market with your name. That is all about the IP strategy. Next slide. Next slide. And let me tell you why this IP literacy and IP culture is important for the academic institution. For the first time in the history of India, in 2016, Government of India has come up with a national IPR policy. And in the IPR policy, there are 7 objectives. Next slide, please. Out of these 7 objectives, next slide, please.
Yes, sir. Yes.
Next slide. Yeah. No, previous.
Previous slide, yes, sir.
Yes. Now here, you see, this is very important for all educational institution, R&D institution. The focus on improving IPR output of research laboratories, universities, technology institution and other researchers. Encourage researchers in public funded academic and R&D institution in IPR creation by linking it with research funding. So now the policy says then even the research funding should be linked with the IP generation. If a particular researcher is not giving IP output continuously in the research grant, then probably research in the future research grant may be denied. That in nutshell is a part and parcel of this national IPR policy. It connotes, it indicates in that direction. I'm not saying it will be stopped, but it indicates in direction. So what I'm trying to convey, even at the national level, there is a framework which says there is a national IPR policy which put emphasis in addition to IP literacy that yes, even the IPR output, I'm not talking about the research paper, etc., because output could be measured in that area also. No, it says that IPR output, the rights, the IPR output should also be visible if, in a research project. Next slide. Next slide. Next slide. Yes, please hold on. Previous. So basically, here you see academia and industry. Now I am come to another interesting point. See, the linkages between universities and industry is very important. Why? You see, I am very happy to note that you have that GIFT has also been given project from NILCO. Now what happens? You see, industries realize that the core of innovation and research ecosystem is with the universities. Universities define the core of innovation ecosystem. There are sources of innovation, new knowledge and skills. They realize it. But then there is another interesting thing. The industry is basically, it's all about commercial application of new knowledge. It's about profit, jobs. See, unless until there is a vibrant industry and a vibrant academia, and then in addition, there is a linkages between these two. Without linkages, industry will be operating in the vacuum. It will be denied the continuous supply of innovative new ideas, new knowledge, so that it can sustain, it can compete with the other industry. Unless until this continuous source is not supplied to industry, industry will become stagnant. Similarly, if the backward linkage is not there, if what industry desires is not visible to the academia, their research will be in the, maybe it will be just to, what should I say, to satisfy the ideal pursuit of your intellectual curiosity. That could be a good thing, but in the long run, it cannot be sustained. It may not be sustainable for the benefit of the society. So basically, IPR provides the link between the university and the industry. What I am trying to convey, that IPR could become the currency of collaboration between the industry and the universities. You see, if a university is having a few patents in a particular technical area, this university is in a stronger wicket to approach the industry. That look, I have got expertise in this area. I have this 10 patents. Why don't you collaborate with me? And similarly, if industry is ready to collaborate, and then there is a collaboration, it's something out, some output is coming out, then the IPR could be a measure of the collaboration. If there is a IPR, then obviously something important thing was generated out of this collaboration. And if this IP is generated and taken protection, then industry will be more interested in further collaboration. So basically what I'm trying to convey, you see, IPR could measure, IPR will become a measurement matrix also of the output of the research collaboration between industry and the academia. And then it could also give a measure to the industry. If the academia has a IP output, then industry will know that yes, they have got certain expertise. Of course, in industry can have a number of research papers, but research paper could be about the abstracting idea also. But when you take a patent, let me tell you, patent taking is a costly affair. Even in DRDO, if was filing one patent application, maintaining grant after grant, maintaining for 20 years, it was spending 4 to 5 lakh rupees. You see, no industry will file a patent, or academia will file a patent just for the sake of it. No, it's a costly affair. You see, earlier I have given you names of the, I have given you the names of the so many industry filing PCT application or patent application and so many. You see, industry, for every rupee is important, every dollar is important. No industry will file a patent just for the sake of it, just to have some flag just to have some feathers in his hat. No, no. It's a question of life and death for them. They will not file a patent application unless until there is a benefit. They are not fools. So what I am trying to convey that please remember that IPR become a currency of collaboration. Next slide, please. Now I will quickly wrap up. Another 10 minutes I will take. Next slide. So basically, why this collaboration is important. Second bullet I will highlight. University, because our placement, university is basically working in the basic sciences, industry in the production, R&D, development and prototyping. So you see, university cannot produce a number of items. Similarly, in DRDO, our work was to give a prototype, prove it in the field trials, and when it is proven, then we will give bulk order to, say, Bharat Dynamics Limited or ordnance factories. Our work was up to prototyping only. Universities at the another level of technological area, basic sciences. So basically, our placement, our mandate is that university cannot compete with industry. Industry cannot compete with the universities, because their mandate is different. Their operational ecosystem is different. But of course, they need to collaborate. There has to be stronger linkages. Then only the society will sustain, the industry will sustain, then university will sustain, R&D institution will sustain. There has to be linkages with the market, as Principal Sir has pointed out. Next slide. Next slide. So basically, and in a academia, in a R&D setup, there has to be IPR cell. I was happy to note that GIFT has got an IPR cell, universal cell, and basically this IPR cell should have people who have ears to the ground. They should continuously interact with the professors, the student committee. If any IP is generated, if university has been given some project, they should help the project PI, the project investigator, to identify the state of the art in his area. They should not reinvent the wheel again and again. If they should take a jump start by making a patent landscape report, they can help the PI in taking a jump start. They can take a jump start. Okay, this is all known. I can take this knowledge, prior knowledge from the patent document, and I will try to solve this problem given by industry with the available knowledge in the patent document, and then add my again delta, and then try to solve this problem. So you can take a jump start. What I am to convey, and if something is generated, immediately take a IP protection. So you have to have a very vibrant IP cell in the university ecosystem, and the person responsible should have proper soft skills, so that they are interacting with the academia. They should be exposed to the other IP networks also. They should be aware what is happening throughout the world. It should be very, very vibrant. Next slide. Next slide. So basically, this is very important slide. I will spend 1 or 2 minutes. Basically, this IP is not something which comes out of the clouds. No. What is this? You see, this part of the focus on this part, the second, this pyramidal part. Basically, once the scientists join a R&D laboratories, or a professor joins a university, or a PhD scholar joins, every day is producing data, document, drawing, know-how, etc., etc. But basically, once this data, drawings, or some processes, products, if they crosses a threshold, then it becomes a fit. His data becomes a fit case for taking a patent, design, or trademark protection. Now, as long as the activities are confined within the university, university, then no question about who owns the IP right. Maybe the university owns the IP right. But the problem is, in today's world, nothing can be achieved sitting in silos, in ivory towers. No. We have to interact with other people on day-to-day basis. In an organization like DRDO, it was interacting with more than 1,000 public sector agencies, universities, outside universities, setting up consortia, research center of excellence, etc., inviting consultants. See, collaboration project, contract project, granting project. We try to take knowledge from outside world also with the proper IP mechanism. So we have collaboration, we have worker, we have giving work order to vendors, contract research, consultancy. And when you start interacting with the other outside world, the complexities arises. Who owns the IP? If you invite a consultant for some work, if some consultant makes your design of your website, who will own the source code? Can you modify the website without his permission? If you invite somebody for invited lecture, can you use his idea without his permission? If you are taking a project from NALCO, if something is generated, do you have right to license the IP generated from this, or you will have to seek permission from the NALCO? Or NALCO have not given you any right to. You see, NALCO it could be ABCD, any organization. If you have taken a project for DRDO, can you use it for own purposes? If something IP is generated, can you exploit it? Who will tell you? This is the job of the IPR people. What I am trying to tell you, that things are becoming very, very complex because of the nature of our interaction with the outside world. We are interacting with the outside world in variety of manners. And unless until you have necessary in-house expertise which can tell you, if you start interacting with the outside, if you take a project, what are the IP position? If you are taking a project from the ST, what are the IP position? Do you have a right? Will it be worthwhile to take a project or not? If you are investing your intellectual efforts in solving some problem and without having any access to the IP, what is the use? So all these things are becoming very complex. You should have necessary in-house expertise to decipher this thing, to know how to provide the contractual arrangement so that you enjoy also the IP rights. Let me tell you, in DRDO when I was working, filing patent design copyright application has become a routine kind of thing. The maximum time I was spending in crafting this IPR provisions for this various contractual mechanism. We were interacting with third parties in a variety of manners, variety of mechanisms. For all mechanisms, we have to have separate IPR provisions. We are interacting with some foreign agency. What should be the IPR provision? That was becoming a very, very tricky situation. Next slide, please. I will just wrap up in 5 minutes. So basically, when I was in IPR, so IPR group, basically you can replace IPR acquisition DRDO, you can replace your DRDO with GIFT. Basically, so the IPR group should not only be interested in filing patent copyright design application, they should also start preparing patent landscaping report so that the PI can take a jump start. They should also have necessary expertise to decipher the collaborative agreement. Then they should litigation, of course, they should at the moment they did not bother. Then maintain the databases, patent 20 years. For 20 years, you have to maintain databases. Then you have to interact with the necessary. For example, you should interact with other agencies, NRDC, CII, FICI, etc. What is happening? So basically, you should, as much you are interacting with the other people working in the area of IPR, you will be learning the what is happening, and then you can bring that knowledge and then imply in your in-house university also. Next slide. Next slide. So basically in DRDO, if you take a granting project, I was just trying to convey different mechanism. So joint right, if you take a project from DRDO and under granting mechanism, joint right, and even the university can own the right and exploit it for other than government application. Next slide. But there is another mechanism. Next slide. If you take a project under contract research, then the other mechanism. DRDO has all the rights and the PI has no right. Why there is a difference? I cannot detail, but there are some valid reasons. So what I'm trying to convey, a single organization can have different mechanism, having different set of IP templates, for having different set of mechanism for joint rights or single right or publication, etc., etc. Next slide. And then patent, let me tell you, I will just just wrap up in the next 5 minutes. What is basically patent is set up exclusive right granted by government to applicant for a limited amount of time return for disclosure. So you want to take a patent, you have to disclose the invention. Next slide. You have to disclose the invention, and this disclosure makes the patent document. You have to describe the method of performing the invention with the help of drawings, working example, etc., etc. And once you file this patent application, then after 18 months, it becomes a part of the public domain. After 18 months, anybody can read the patent document for the invention for which you have filed a patent application. But for 20 years, he cannot copy it. But he has all the rights to study it and then improve upon it. And if he is able to make an improvement, further delta, which is novel, non-obvious, then he can file another patent. And that is the beauty of the patent system, ladies and gentlemen. You see, just by the fact that you have filed a patent application doesn't mean that the knowledge has stopped in that area. No, your competitors are keeping a track what you are doing. They will be studying your patent, future patent. And if they are able to improve upon it, they can file a separate patent. And be reminded, even if your patent is granted, if your competitor introduces a further delta on your patent, and if that patent is more valuable, it makes your patent redundant, then your patent has no value. Look, you see what is happening. So that's why the patent system adds the competition. You just cannot rest, even if you have made a wonderful invention. Others are waiting. Others are waiting to improve upon your invention. Look, Nokia was a powerful brand in India. Where is Nokia today? Gone. They could not capitalize. They could not foresee that dual SIM is going to rule the market. They did not. They could not catch up with the market. So Samsung, Apple. You see, no wonder they are always in competition. Who adds a value delta ahead of competitors? Who file a patent application? Who enjoys the monopoly rights? Who can introduce in the market to retain the leadership? So patent system, that is why, coming back to the second slide, that patent culture inherently fuels competition. There is a spirit of competition and knowledge sharing, because patent you file, the knowledge is disclosed for it after 18 months. Everybody can know what you are doing. After 20 years, they can copy it. So you are forced to make improvement upon your own inventions. Otherwise, your company will become stagnant. Others will take advantage. That is why the beauty of this, that's why the companies are always investing, always trying to improve upon their own product. Next slide. Next slide. Next slide. Next slide. Yes. So for patent, you have to three barriers: novelty, non-obviousness, utility, and then, of course, you have to describe the invention. And of course, it should not be section 3 and 4. I will not detail. It should not be unpatentable inventions. So basically, next slide. Because time is, yes. So section 3, 4, section 3, they list out some area that in this area, for example, traditional knowledge patent will not be granted. Section 4, atomic energy patent will not be granted. Next slide. So there are three mool mantra: novelty, non-obvious, and useful. I will not go in detail. Maybe another workshop on this patenting system. Next slide. Next slide. Next slide. Yes. So that's the end of my presentation. So basically, the idea was that IP literacy, IP culture should become a necessary part of the all the researchers, all the researchers, the academia, the scientists. Only then our society will progress. Because that is the beauty of the patent system, the IP system. It inculcates the spirit of innovation, the competition, the cutthroat competition, may I say, introduced in the market. Otherwise, the company will not survive. So it is a fuel. It provides fuel to the competition, and that's why the society excels. That is why the initial 3-4 slides, as you see, that indicates the intensity in patent activities in IP area also connotes the technological leadership. Thank you. Thank you.
Thank you, sir.
So any questions?
Yeah, thank you, sir. Now I'd like to request our participants, those who want to ask any question to our speakers, please ask.
Sir, I have a question.
Sure.
Avinash, sir.
Yeah. Please
Sir,
go ahead.
Sir, what will be the cost of a patent from filing to get a patent? How much cost?
Yes. You see, the cost will be, it depends. Suppose if it is institutional, if it is institution, then the filing will be say around 8 to 10,000 rupees. Totally, if you maintain for 20 years, it comes around 4 lakh rupees. For individual, it is less, 4 times less, 25%. But let me tell you, for individual to take a patent is a very difficult task because it's a very techno-legal document. And then even if you take a patent, how to exploit it, basically individuals should have some backing from an institution. Okay, that's what I want to convey. But initial filing itself will be around 30 to 40,000 rupees. 30 to 40,000 rupees.
Okay, how much time it will take to get a patent after filing?
After filing, now it is 3 to 4 years. 3 to 4 years, but that is the worldwide 3 to 4 years. Even less, there are some mechanisms, expedited examination, etc. But normally it is 2 to 4 years.
So the 20 years filing is valid from the date of filing?
Date of filing, 20-year term. 20-year term.
20 term. Yeah. Okay, sir.
Okay, thank you, sir. Any more questions from a participant side? If anyone is interested, yes. Any questions? I think someone.
Hey, good afternoon, sir. Hello. Sir, I just want to know about the delta value. Initially, you have put emphasis on that delta value. That is whenever.
Okay. Let me tell you. Yes. I will explain. I will explain you.
Yeah, my question is related to that one. Sir, before we are getting a concrete idea, so during the course of time, and that is what we preoccupied, what is we are getting from the experimentation. Sir, how can we signify it? Whether it is viable, whether it will be further carrying out or like that, sir. So,
I tell you what. You see, if you are working in any technological area, you see, the scientists, I have interacted with so many scientists for so many years. Scientists have this gut feeling that yes, they have. I used to say that if they have come across some surprising result, the result which surprises them, then there is a good chance you have made some good data contribution. But let me tell you, this measurement of data could vary from field to field. Interesting example. You see, the girl used to type, and when she used to type, the hair will fall. Okay. Now the hair will fall. There was a wire. The wire was bent. It becomes a hair clip, and that hair clip has got utility you can understand. So it becomes a patentable invention. So it depends in what area you are working. You see, that is why we say innovation, something which immediately attracts to the market. But let me tell you, caution you, as you are a researcher in some area, it will be a good idea that if you feel that you have made a delta, how to validate that delta is patentable or not. So patent search. If you are in a habit of carrying out patent search, Dr. B.K. Sahu can conduct another lecture. He will be a good speaker that how to carry out patent search. If you carry out a patent search or you are in a habit of continuously carrying out patent search in your area, you know very well whatever I have contributed is patentable or not. Okay. But I always used to tell my scientists, in doubt, file a patent application. Let the examiner say that it is not patentable invention. Okay.
Okay. Thank you, sir.
Thank you, sir. Any more questions from participant side? Okay. I think even I have not received any questions in that chat box. So thank you, sir. on behalf of our National Innovation Startup Policy at GIFT and Institutions Innovation Council of GIFT. So I would like to extend my sincere gratitude and thanks because of your valuable time, and you have been enlightened the particular session regarding intellectual property rights and the culture of excellence. I hope our participants enjoy the session and they learn a lot how to protect their idea, POC or prototype with respect to IPR support and knowledge transfer. So thank you again. So because we are right now running this for time, because another speaker right now will be invited for the particular session. So thank you so much on behalf of the entire GIFT family. I would like to extend my sincere gratitude and sincere thanks to you, sir. Thank you, sir.
Thank you. Thank you for your attention. I really enjoyed this session. Thank you, my dear. Thank you.
Thank you. Thank you, sir. Thank you. Thank you, participants. I think now we have another session, maximum 5 minutes break because there is a logistic requirement for the next session. So within the short time period of 5 minutes, I'll arrange the entire thing and you will be joined with same link. And by now time is 12:11. I think by 12:20 maximum we'll invite our next speaker, Dr. B.K. Sahu, and he will join. I hope you also enjoy the session. Whatever the queries you are having for the first session, you might have cleared the session also that particular answer in second session because there are a lot of queries from student side. I remember that whenever we arranged the same session last time in the physical presence of Dr. B.K. Sahu, there are a number of queries asked by our faculty members and also queries by our students. So I hope this is the right time to discuss with Dr. B.K. Sahu in the second session. And for the time being, I think we should leave right now, and by maximum 12:20 you will join. Thank you. Okay.